I'll pass the witness.
Ms. Duff?
Thank you, Your Honor. In looking at these doctor's records on page, well,
Which one? P1 or P3?
let's start on P2, I believe is the first
Okay.
one.
Mhm.
That's the one on
829?
the 29th.
Mhm.
That's the day after she was removed, correct?
Correct.
If you scroll down to page 6, it says she was diagnosed with reflux, correct?
Mm-hmm.
And after that, it's a 3-day placement. Is that correct?
Mhm.
Okay, it really wasn't a 3-day placement, it was a 1-day placement, correct?
Objection as to the form of the question.
Nova had
overruled.
just been in her
It's
placement.
overruled.
Okay. It was just a 1-day placement. Correct?
Correct. At that point in time, yes.
Okay. And now this was a doctor who Ms. Pringle had been taking Nova to visit, correct?
Correct.
And was this the first time that he noted reflux?
I could only speak on the records I have before me.
Okay. But Ms. Pringle had been taking him to the doctor. I'm sorry, her to the doctor, correct?
Yes. Yes.
Okay. So she was concerned that there was something wrong.
Yes.
Okay. And there was something wrong, right?
Yes.
Okay. So then let's go to P3. Oh, I'm sorry. Let's stay on that one. On page 8, it says cancel the UT neurology appointment, correct?
The court moves away from emotional allegations and starts applying legal standards. The judge isn't looking for who made the better argument anymore. He's looking for whether the evidence actually reaches the burden required to justify a custody change.
Yes.
All right. So is this the doctor that recommended she go for a neurology appointment?
Yes.
Okay. So Ms. Pringle is actually following what the doctor said to do with regard to what her symptoms were, correct?
Objection as to speculation.
Well, she made the neurology appointment.
I think I'm going to object because I think Ms. Pringle's testimony was that was recommended when she was in Texas Children's. I'm going to misstate facts before the court. I think her testimony was that was made during.
That's sustained.
Okay, thank you, Judge.
There was a neurology appointment made, is that correct?
By the department? No.
I'm just asking. There's a neurology appointment referenced on page 8.
Yes. And it was referenced to be canceled.
Okay. And the cancellation was due to Dr. Webb's recommendations.
Yes.
Okay. Now, you also stated that you have 2 other sets of medical records from Dr. Webb's office. Is that correct?
Yes.
Where are their records and all these records that CPS keeps?
I did not provide it in this case.
Okay. So did you not think that some of those other records might contain some information that the court might need?
Not necessarily.
Okay.
And I'm not the custodian of it.
I'm sorry, what?
I'm not the custodian of those records.
You didn't
For
have-
clarification, are we talking about all of the records from
No,
the
this-
doctor's office?
No, she referenced specifically 2 other sets of
2
medical
other sets of records.
that she has, but
Mhm.
she doesn't
That
have
came
them.
from Miss Pringle. I think that.
No, she says she got them from the doctor's office.
No one else have the copy of that. That's what I was doing. My
No one else
research on-
has what?
I was doing some follow-up on Nova, and the doctor office provided me with a copy of that record. So that's the record I was reviewing with the doctor. This
But
is
you-
prior to the removal.
And but you did not put those in DFPS's records.
No.
Okay. Why did you not put those records in Nova's file after you took her into custody?
It wasn't an official request, first of all. I was simply following up on the allegations that Nova could be epileptic.
Okay.
So I was looking into that because Ms. Pringles would have communicated to me that she believes Nova is epileptic.
Okay. But Ms. Pringle is not a doctor, correct?
And neither am I.
Okay. But she was taking Nova to a doctor to try to find out what was wrong with Nova.
Objection asked and answered.
And isn't that to be expected of a young mother?
Overruled.
Okay, she was taking Nova to be to see a doctor to see what was wrong with her. Is that correct?
Correct.
And that's expected of a newborn's mothers. Is that correct?
I would hope of any parent.
Okay. So Ms. Pringle was doing what she needed to do.
Mhm.
Okay.
Objection calls for speculation in full. It's a very summary statement. Conclusory.
Overruled.
Okay, objection to the form.
Overruled.
She answered it, I believe.
Mhm.
How often have you observed Ms. Pringle late at night?
Not very often.
Okay.
Hmm.
In your experience, even just in your own experience, do people's demeanors change when they get really tired?
Objection calls for speculation.
I said in her experience and including her own.
Objection relevance of her own demeanor and speculation as to other people's demeanor.
Relevance is sustained.
Did you see me sitting in court on Monday after lunch?
Objection sidebar argumentative.
No, I'm
Relevance.
Overruled.
Relevance.
That's sustained.
Okay. Have you ever seen Miss Pringle when she was tired?
Yes, I have.
Okay. Do her eyes kind of droop?
She tells me she's tired and I see it in her face.
Okay. So her demeanor changes when she gets tired. Is that correct?
Correct.
Okay. But this is the first time you had woken her up late at night. Is that correct?
I don't know that I woke up.
Okay.
Objection is to misstatement of the evidence.
This is the first.
That's overruled.
Objection misstates Miss Allen's testimony of her.
Well, she said that she didn't know, so it's okay. Let's go on.
The discussion surrounding joint decision-making exposes a common tension in family court. Many parents assume conflict automatically destroys the possibility of joint legal custody. Courts often see it differently.
You were not at these doctor's appointments, correct?
No.
Okay. I'll pass the witness, Your Honor.
Miss Ortiz-Ting?
Judge, 30 seconds while I run to a different room because I'm working from home
Okay.
and the dog started barking.
Okay.
Okay. Miss Allen, your testimony is that you saw this mom many occasions, many a time, correct?
Correct.
And then you talked about with your cross-examination with Miss Osina, how this was comparable to the incident on December the 23rd, correct?
Correct.
Okay. And the consequence of the visit or what you saw on December the 23rd was to reduce or increase mom's level of supervision again with Layla, correct?
That's correct.
Right. And so that is actually what you're trying to do here today, correct?
Yes, the goals remain the same.
And you're trying to ensure that the department is consistent actually with what they did December 23rd and now what they're doing now, correct?
Correct.
So in between, there was some improvement by mom or CMID improvement by mom, correct?
Correct.
So we're talking about we're talking about 7 months difference, correct?
Correct.
And one would expect that in 7 months, mom would understand that going back to using or overusing methadone would be a concern, correct?
Correct.
So do you believe that the removal or the attempted removal that you're engaging in today or continuing this removal is actually consistent with what the department does?
That is correct.
Okay. So let's back up for a second here. You testified that you witnessed slurring, drooping and closing of the eyes, correct?
Yes.
And the moment that you saw that, you were concerned, correct?
Yes.
Okay. And so you hadn't seen Brittany like that for 8 months, fair?
Since last year.
Yeah. And 8 months ago when that happened, you tried to send her for a drug test and she wouldn't do it, would she?
That's correct.
And it took probably about a month before you got that drug test taken, didn't you?
Yeah, it took a while.
Yeah, let's talk about that for a second. So you
Objection,
went back to the
relevance,
door
Your Honor.
and you knocked on it and there was no further answer, correct? Can
Yes.
y'all hear me?
Mm-hmm.
So let's talk about that. You got no cooperation from Brittany December of 2023,
Oh,
correct?
I thought we were talking about August 2023, whenever you said you went back to the door.
Judge, they opened the door to December in their, just communication with Miss Eileen. So I'm making comparisons.
I
I think it's relevant.
never brought up December 2023.
Absolutely brought up by Miss Osina.
The department brought up December 2023, mentioning that there were
Let's
two
go forward.
instances that she has seen this.
All right.
And the door has
So
been
there's,
opened.
The door has been opened.
I said go
So-
forward, please.
Okay, thank you, Judge. So you had no cooperation from this mom and could not get a drug test in December of 2023 until January, correct?
That's correct.
How many days did it take for you to get cooperation from Brittany, or if you know, from George or Jorge?
Jorge.
Jorge's testimony. It took 5 days before he was able to sit down and talk to this mom, correct?
Objection misstates the
That's sustained.
previous testimony.
That's sustained.
What? True or not true that the child was seen by you guys on Friday, December the 23rd?
True.
And true or not true that his testimony was that he didn't see her again or was not able to see the child or Miss Pringle on, I think it was August the 27th.
Objection misstates the earlier testimony. Mr.
Sustained.
Galicia testified.
You saw her the next day at 5.
Following day. Yeah.
Yes.
Okay, well, true or true
She
not, she
called
was
him
not
at 11 a.m.
Sorry, I went running up the stairs and I lost my page.
That's okay.
All right. Either way, there was no cooperation on the same evening, correct?
Correct.
And it wasn't until 5 o'clock the next day.
Objection, which evening is she talking about? I'm confused.
Can you make sure, because since you're comparing the 2 months that before you ask the question, you specify if you're talking about August or December?
Sure, will do.
Okay.
In August, there was no cooperation for several hours after the incident, correct?
Correct.
Objection, mistakes evidence.
Silver room.
Okay. And so to your knowledge and from the testimony from Mr.
Jorge.
Jeffrey. No, I'm now Mr. Jeffries. Your understanding is the appearance of being intoxicated or under the influence can pass pretty quickly, can it not?
Yes.
Objection, cause for speculation.
It's
We're
sustained.
we're just reiterating the testimony, Judge, that she heard her understanding from what she heard from Mr. Jeffries.
No, you're objection, or she's leading, but she's also misstating what.
The leading is sustained,
I'm on cross-examination, Your Honor.
but she's not adverse to you.
But either way, I'm on
Aligned.
cross-examination.
Continue, please.
I don't have a lot of time. I'm just trying to get it out there quickly So
Go ahead. And I'm not going to cut you off exactly at 3. I know you're trying your best.
Okay, thank you. Now, in regards to those medical records that were before you, the baby weighed 9 pounds, 15.4 ounces, correct? In the one on August the 29th, correct?
29th? Yes.
And then the baby weighed 10 pounds, 2.3 ounces in the next record on September the 5th, correct?
That's correct.
All right. And just of note, there was a little bit of growth in those 6 days. Is that fair? In
Yeah,
her weight? Okay. And then with regard to Layla on the couch, was there anything on the couch? I think was the question. Did you know
Nova on the
anything
couch, you mean?
who's sleeping? There was a question by, I think, Miss Osina. Was there anything on the couch that you saw? Pillows, bedding, anything like that?
I recall seeing cushions.
Okay. And with regard to, did you sit on the couch at all?
No, I did not.
Okay. Did Miss
But
Pringle sit on the couch at all while you were there?
The courts attempt to balance competing narratives without becoming trapped by either one. Every custody case eventually reaches a point where both sides believe the evidence overwhelmingly favors them.
No, she did not.
Okay. So the whole time you all were just kind of standing there with the babies or the
Correct.
baby and Layla was sleeping in the other room?
Yes.
Okay. In the time that you've been the caseworker for Novaline, have you visited or seen her in the foster parents' home?
Yes, I have.
When was the first time did you put Novaline into this foster home on one day?
The 28th of
29th?
August. 28th.
Okay. And then when was the next time you saw Novaline?
It was last week. Last week, Thursday?
Objection
Last
relevant, Your
Thursday?
Honor.
Sustained.
And well, I'm asking how the baby's doing. I'm trying to get there. Have you?
We're talking about an adversary hearing and what was happening up till the time the baby was removed, Your Honor.
I agree.
Right. And does the baby look well to you?
Objection.
Yes, she
relevant,
does.
Your Honor.
It's overruled.
At the time of your placement, what time was it?
It was after 11 at night.
Okay. And at that time, was the baby clean and in good condition?
She was wearing a onesie. She was congested. So we would have gotten from Miss Pringle the suction bulb to remove the mucus from her passageway.
Okay. And you attempted to place the baby with, or we're hoping you could place the baby with her mother, correct?
Yes, Miss Pereira.
Okay. And she's not able to take the child, correct?
No, she's not.
All right. Did you all have and make any efforts to try to reach anyone else to try to avoid a removal?
No, the only other person would have been Mr. Bird. And right now on the sister case, which is Layla's case, he's not supposed to be in a certain feet or distance from Layla. So based on those circumstances, we didn't think it was right to reach out to Mr. Bird for as a placement.
Okay. And so regarding Ashley Bird's testimony, did you hear her testify that she had information that mom had rolled over on Layla?
Yes, I did.
Objection, hearsay.
Sustained.
That was based on Miss Bird's testimony, Your Honor. Did you hear information that?
I think that was also sustained during Miss Bird's testimony as well.
I think that was what she said Miss Pringle had said to her.
Correct.
I'm sustaining the objection.
Okay. As far as your work with Miss Pringle, you were the caseworker for this case, correct?
Yes.
You are the caseworker for Layla's case, correct?
Correct. Correct.
You are the caseworker or were the caseworker for Mr. Williamson and Hunter and Annabelle, correct?
Correct. Correct.
And so when you see someone who has, and this child, Miss Pringle had prior history with Hunter and Annabelle, correct?
Yes. Yes.
So when the door is opened with a mom with a knife in her hand, a baby in the other, and you witness slurring and drooping of the eyes, are you actually afraid at that point?
That was one of the reasons. Yes.
Okay. And so you're not allowed to remove children just because of risk, correct?
No.
Did you perceive this to be just a risky moment?
No.
Did you perceive this to be a very scary
Objection. Which moment
reality?
is she talking about, Your Honor?
Opening the door and witnessing the slurring, the knife in the hand, a baby in the other, and
So the 23rd.
the 23rd. Did you perceive that as a scary moment?
Yes.
Okay. And then subsequent to that, do you believe you reacted reasonably under those circumstances?
Yes, I did.
And since then, have you become more concerned?
Yes, I have.
And that is as a result of your communication with Dr. Webb, correct?
That is correct.
All right. And are you aware of more than one allegation coming in regarding this infant?
Yes, I have.
How many allegations at this point?
From Miss Ashley, from Dr. Webb, from Mr. Williamson,
Okay.
and
And one more. This is the one that we're here
yes,
for our own, so to speak.
yes,
Okay. So at this point, there were 4 different concerns and allegations regarding this mom and this children, and as well as Layla for that matter, correct?
correct.
All in the span of about 2 to 3 weeks,
Yes,
and all from different people,
yes, yeah,
seeing this mom at different times.
yes,
And so when you guys came to this court, you didn't come lightly asking to remove Novely, did you?
no, we did not.
You believe that this mom is abusing her methadone, correct?
Yes,
Somehow, some way, correct?
correct.
You don't know how exactly, but that's what you're afraid of.
Objection.
I am-
has been answered.
Sustained.
You believe it's in the best interest of this child and for the reasonable care and protection of this child for the department to be granted temporary managing conservatorship, correct?
Yes, I do.
And to put this child back in Miss Brittany Pringle's care prior to getting the segmented methadone hair test to see exactly how much methadone has been used in the last 90 days would be very, very unsafe for Novely, correct?
Correct.
I'll pass the witness.
No questions, Your Honor.
Okay, well, 3 minutes ahead of schedule.
I went as fast as I could.
I told you didn't have to.
I know, but it was,
Okay, so I want to make sure.
A deeper issue emerges when the discussion turns towards safety concerns and risk assessment. Family courts are not designed to eliminate every possible risk. They are designed to manage risk to a reasonable level.
Give me just a second here. Since I know you won't be back tomorrow, Miss Allen.
Yes, Your Honor.
Okay. So I just want to make sure that I understand what you're saying correctly. Part of the burden of proof here is that reasonable efforts have been made to enable a child to return home, but there is a substantial risk of a continuing danger if the child is returned home. Am I understanding you that a substantial risk is the possibility of co-sleeping, the threats by Mr. Bird, that Miss Pringle, thank you, set the baby down on the couch, and that after Mr. Galicia asked her to take a drug test, that the results of that drug test were negative?
Yes.
Okay. I'm confused. So one is, okay, well, let me ask you this. Do you believe it is possible to put safety measures in place that would remedy the co-sleeping?
It is desirable, possible, I'm not too sure.
But is that something the department would normally do in a safety plan?
Yes.
Okay. Similar to as in Layla's case, do you believe that it's possible to put injunctions in place for Nova regarding
Yes.
Mr. Burke?
Yes.
Would that put, well, I guess in joining Mr. Bird and in joining Miss Pringle, would that decrease the concern regarding the threats that Mr. Bird is said to have been making?
Your Honor, with all due respect, I've been on the receiving end of Mr. Bird's anger, and I personally am afraid of my life when it comes to him, Your Honor. And I do not
Okay,
think
so let me ask you this question then. What will the plan be for family reunification with either child, with Miss Bird, with Miss Pringle, as it relates to Mr. Bird? Because do you see what I'm saying? Like,
I understand, Your Honor.
Yes, is out of her life and her children were to be returned to her. There has to be a plan in place with regards to Mr. Bird. He cannot just continually be a reason. So what would the department suggest then?
Your Honor, may I speak briefly in the fact that there was an injunction made by the court and Ms. Pringle did not follow that injunction.
Well, it was made with regards, but here's my question is, what would the department propose? At the end of, imagine y'all get the segmented hair follicle test back and you go, okay. And Bruce Jeffrey says, it looks fine. She's done all of the services. At that point, the segmented hair follicle test looks fine. And the only thing that you have left then is Mr. Bird's threats. What would be the plan other than to rely on her to protect her children?
And that's why we reached out to Miss Pereira.
But she can't live with her mom forever. Right? Like, so what do you see what I'm saying? Like, Mr. Bird can continue to be a threat for the next 18 years of these children's lives. Is the suggestion by the department that because he continues to make threats against her and her children, that the children shouldn't be returned to her?
No, we're not saying that.
Or that she should forever need to live over at her mom's house because he makes threats? I'm trying to figure out like what the plan would be.
Ms. Pringle and I did discuss. She said she would be moving next year, but she cannot move right now because it takes a certain period of time before the lease expires. So she indicated to me she would be moving in February and she would not let Mr. Bird know where her location is because she has to protect the kids at all costs. So that was one of the suggestions that we discussed.
So then is it the department's position then that family reunification with her should not be considered until February 2025 when she can move?
We need some time, Your Honor. We need some time
Is
to
that,
put some.
but is that y'all's position? It's just, I'm just asking, like, is that y'all's plan? Is that what your thought is? Is they're not safe with her until February 2025?
I can't put a timeline on it, Your Honor. But right now, they are not safe.
What would go into a safety plan with regards to Mr. Byrd?
The way I see it, Your Honor, even if we put a restraining order out there for Mr. Byrd, at the end of the day, it's going back to what Ms. Pringle and Mr. Byrd discussed. On the 23rd, Ms. Pringle looked me dead in the face and told me she has not
I understand. What
anything
I'm
with
saying
Mr.
is,
Byrd.
what I'm saying is one of the department's concerns is related to the threats against that Mr. Byrd makes against her and the children.
Yes, Your Honor.
I understand that. What I'm asking is, if you didn't already have TMC of Layla, and this was the thing that was called in for Nova Lee, what would the safety plan say for Mr. Byrd? Do you understand what I'm saying? Like, what reasonable effort can the
Can the
department
department make
to
keep it
mitigate the threat of Mr. Byrd and allow for the baby to be with her mom? That's what's required under the law.
Mhm. It's difficult to say, Your Honor.
Okay. With regards to laying the baby down on the couch,
Agencies often possess significant authority, but judges remain responsible for independently reviewing that authority. The courtroom becomes a testing ground where decisions made outside the courtroom must survive legal examination.
how old was she again? A month and a half?
A month and a half at that date.
Okay. And are there measures that can be put in place in a safety plan that would eliminate that concern?
Oh, yes. And Ms. Pringle, at the Layla's initial case, would have communicated that she understood the way she had Layla and now the way she had Nova. I would think she understands that as well, that it poses a danger to these infants.
So the co-sleeping in the couch can be remedied by a safety plan.
Yes, that can
The
be.
concern about Mr. Byrd is going to always be a concern. Is that fair?
Correct.
I mean, from now until he were to clean up his life and become like a sober individual. And right?
Yes.
Okay. Is it fair to say, or do you believe? Okay, let me back up for a second. When did Mr. Galicia send Miss Pringle for a drug test?
It was a Monday. So that's the
So
26th.
the next time the facility was open.
Yeah.
Okay. And I realize the hair follicle test that you all received back did not test for methadone, but then it wasn't positive for any other substances either.
Correct.
So if she was, and I honestly have no idea if you use something on Friday, if it would be in your hair follicle on Monday. I don't know. But at least up until that Friday, for the months leading up to that, the department doesn't have any concern that she was using any type of other illegal substances.
Not that we are aware of.
And then well, I guess even if the UA was tested for methadone on Monday, it wouldn't have had Saturdays per Mr. Jeffrey's testimony. Saturdays or Friday or Saturday's usage wouldn't be there anyway.
Nope.
So then what we have to go on for Saturday is what you observed whenever you were there and what Mr. Williamson says he observed for the part of the phone call that he stayed to watch.
Yes.
Right?
Mhm.
So other than calling Mrs. Pura to see if she could be the placement, did y'all talk about any other reasonable efforts that could be made to eliminate these concerns that you outlined in your testimony?
No, Your Honor.
And if the co-sleeping was addressed, again, the threats are always going to be a concern, right? The couch was addressed. And she's negative for illegal substances. We don't have a methadone test, so that's kind of an unknown.
And Your Honor, for the
Do
record, I'd
you
like to clarify.
believe- Let me finish first,
Yes, Your Honor.
please. Do you believe that there is still then a substantial risk of continuing danger in
Yes, I
Mr.
do.
Pringle's home? And what would be that risk then?
Because we are uncertain about the methadone use, Your Honor.
Okay. Here's my concern.
Mm.
Or here's my question, I guess. That was part of the department's investigation. And the department did the department not request the right test? Or did the facility not perform it correctly, if you know?
The facility did not perform correctly, Your Honor.
So you're never going to know the answer to that. Is that because you can't go back and get a UA from August the 23rd?
No, we can't.
As she sits there today, other than speculating that on August the 23rd, she overused her methadone, which I think is what you're suspicious of, right?
Yes.
What is the plan? Because I can't keep her baby away from her based on suspicions. So if everything else can be solved by a safety plan, and we'll never know what her UA would have been on August the 23rd or the 24th, what am I to go on?
Your Honor, I believe you have the evidence of myself. You have the evidence of Ashley Bird. You have the evidence of Mr. Williamson. I'm sure you're going to hear the evidence from CASA. These circumstances are unique in that there is no one clear path as to the reasons that we are concerned, Your Honor. I've been in Ms. Pringle's life for over a year and a half, Your Honor. And personally, I'm going to abide by any court order that this court awards, Your Honor. However, I will not rest likely if anything is to happen to these kids, Your Honor. I have developed a bond with these kids, and I'm sure Ms. Pringle loves her kids. She's a great mother. However, until she is able to get off this methadone, Your Honor, I do not think it is safe for the children to be there, Your Honor.
So that's where I'm confused, I guess, is because the department is not satisfied if she's negative for methadone.
The safety plan discussion reveals a subtle weakness that often appears in protective cases. Once a witness acknowledges that certain concerns could potentially be addressed through supervision or structured safeguards, the debate changes dramatically.
How could you be
And you're
negative
not
if you're
satis-
on?
You're not
on-
supposed to be negative.
satisfied.
You're not
She's
supposed
Okay,
to be negative.
but what you just said, Miss Allen, is she's not going to be a safe mom until she's off of the methadone.
And she told me she's coming off.
And so
I think it was a misuse concern in terms of the negative rather than her just being negative.
It's the same as alcohol, Your Honor. It's anybody who overuses or abuses an illegal substance it's still not okay.
I understand, but per Mr. Jeffrey's testimony, she could have a negative depending on if she took it before she tested that day. I don't know any of that information.
Your Honor, Mr.
We're not-
Jeffrey's testimony was that she would be negative, except for the fact that she's on methadone treatment and taking it twice a day. She should never be negative.
I agree.
The negative possibility came into realm was if it was like a once every other day type of use. But Mr.
Okay,
Jeffrey
here-
specifically testified that if she is on this methadone treatment for twice a day, she should never test negative. And that
Here's the
testimony came up
issue.
earlier.
Here's the
testimony-
issue, is that I have to decide whether there's a substantial risk of harm that cannot be alleviated by reasonable efforts. And to be honest, I don't know what Dr. Webb is going to testify to. I'm assuming that the baby gained weight based on the medical records that have been, that the questions that were asked and the records that were provided. But I'm just not also going to take issue with, from what I understand from the testimony, Ms. Pringle was concerned enough to take her baby to the emergency room. She took her baby to the emergency room. The emergency room doctor admitted the baby to Texas Children's Hospital because that's the only way you can get
Mhm.
in, right?
Mhm.
The
Correct.
baby stayed for a period of days.
Mhm.
I think we can all reasonably assume that during that period of days, the Texas Children's Hospital pediatrician or neurologist or whoever it happens to be was monitoring the baby over the course of that time. Right?
Mhm,
Yes or no?
correct.
Yes.
Yes.
None of the referrals are from Texas Children's Hospital. And at the end of that hospital stay, when the baby was discharged, she was referred to neurology.
Your Honor, that's all speculation based on what Ms. Pringle's testimony. We don't have anything to substantiate this at all. We don't have medical records from Ms. Pringle. We don't have anything to state what Ms. Pringle is telling us.
Have you asked
Dr.
her,
Webb-
have y'all subpoenaed them?
We don't have the dates that Ms. Pringle has
Well,
supposedly
she
taken. this
testified
baby.
to them.
She
And I have
testified-
asked Ms. Pringle to provide me with those records since the
And
onset. She told
She
me.
testified that she wasn't sure exactly when, but it was sometime after Hurricane Beryl.
Right.
Your Honor, when
We've
this
been trying
case
to narrow
first,
it down.
You all know that you don't need exact
E-
dates to
either
subpoena
way,
records, but my
we still
point
have-
is,
TCH, we do need specific dates or they won't provide us records.
they have authorization for TCH because we just looked at two sections of them. Texas Children's Hospital records and Texas Children's Pediatric records are within the same system that they have access to.
No,
And the child, I
doctor will
believe, was
testify he
discharged
doesn't
in
have
Dr.
access
Webb's
to the
saw.
hospital records. No, the doctor will testify that he doesn't have access to the hospital records. I'm
But if
sorry.
Dr.
We're
if Dr.
now we're
Webb has
talking about
seen
stuff that isn't even before the court yet. That witness is scheduled to testify on Tuesday.
So I'm not really sure why we're going into his possible testimony.
because I don't know that it's necessary. I don't know that it's relevant and that it's going to impact my decision. So to take the time out of his schedule on Tuesday to ask him
He's willing to be
testify,
here, Judge. He's willing to be here.
I
He's
just
on
don't-
leave.
there's I want
Your Honor, from the very beginning of Layla Bird's case, the court wanted to see consistent levels of Ms. Pringle's methadone use. The the court has received plenty of lab reports showing that those uses have not been consistent. Even someone from the El Dorado Clinic testified that in a previous case that that she should not be negative. If the honor was to look at Ms. Pringle's lab reports, disregard the fact that the lab did not do the correct test on this and tested for bath salts, and instead, the department sent her for the specific reasons of getting that level. She tested negative the day before this incident, which indicates that she has not been taking her methadone treatment the way she's supposed to. Because regardless of what time or what morning, whether it's 8 o'clock or 9 o'clock, she is to have consistent methadone in her body. And Mr. Jeffries did testify.
Hang on just a moment. I'm sorry. Give me just a moment. I'm sorry.
Go ahead.
Where I'm at right now is I will listen to argument as to why I shouldn't give her baby back today. I thought that at the end of Miss Allen's testimony, that there would be more than speculation about the substantial risk of harm.
There is, Judge,
Be
with
to
all
know
the
the lead.
taken into consideration.
Taking in everyone else's testimony, Your Honor, there's an indication that Miss Pringle was on some kind of substance at that time that caused concerns from not only Mr. Williamson, but also from Miss Allen. As Miss Allen stated, we're not talking about, one incident. We're talking about a continuous course of action that Miss Pringle has in her failure to maintain her methadone treatment program, which is why we sent her for a hair follicle in hopes that would help out.
Well, and it's not just that. We have work to get
One argument at a time, please. One argument at a time. And
we're
we'll go
arguing?
counsel. Yes, that's what I asked for.
Oh, I didn't realize we were arguing, Your Honor, because technically CASA hasn't spoken yet, and I believe that they have the best interests of the child in mind and should be heard from as well.
No, I'm asking for argument because at this point, and unless there's going to be, like, Miss Beatty was not there on that night.
She was in the morning.
She was there
in the
earlier.
morning, Your Honor.
Medical evidence
so-
becomes the center of gravity during this phase of the hearing. What makes this important is not the diagnosis itself, but the reliability of the information being presented. Family courts depend heavily on expert records because judges are not physicians.
And so
She's had plenty of conversations with Miss Pringle to also confirm that there was co-sleeping done. There's been conversations with Miss Adams and Miss Pringle that they have serious concerns for returning this baby, Your Honor. So
one person
and
at
so-
a time, please.
if the department is concerned, if CASA is concerned, if the child's attorney is concerned, Your Honor, based on just those actions that was observed on the night of August 23rd, that should raise concern to the court as well, that this baby is not safe at this time until Miss Pringle actually maintains her methadone treatment according to plan. And until she is able to control that methadone, originally it was okay, as long as she's keeping up with the methadone treatment program correctly. All these lab test results, along with the testimony of Mr. Williamson, Miss Ashley Bird, Miss Stacy Allen, even Mr. Jorge Galicia, by her avoiding CPS contact, all these indicate that she has not been maintaining her treatment program as required. And therefore, if she tests negative the day before this incident, when she should never test negative, and then she's showing symptoms of methadone use based on what her demeanor showed Miss Allen, that is another indication that she is misusing her methadone. And even Miss Pringle has made statements knowing that methadone has been the cause of these issues, that she is willing to work in getting off of methadone. Your Honor, the plan is to help her in that, if that is her plan, and also provide her to a different treatment facility where they are better regulated than we believe El Dorado Clinic is. We're not saying that this baby is not. The concerns that we've explained through our witnesses is that this baby is in danger, and I myself, as well as CASA, Miss Ortiz Tang, Miss Allen, Miss Fisher, that we're going to end up with a dead baby in this situation. That's the biggest concern, because co-sleeping alone, that itself and it's concerning if you're on drugs and you're not able to substantiate when your baby is awake. Using your methadone and not being able to care for a newborn, that is concerns for everyone involved besides Ms. Pringle and Mr. Bird. Your Honor, everyone in this case has been involved with Ms. Pringle for a year and a half, and the concerns we have are not light concerns. We are talking about a 2-month-old that cannot even crawl away from an intoxicated or inebriated mother. And I'm not saying Ms. Pringle is a bad mother. I've observed her myself. When she is not under the influence of substances, she takes good care of her kids. I'm not saying that. But Your Honor, there is a concern with this methadone treatment and the way she is interacting with her children. And that causes the concern for the safety of these children, which in turn, the best interest of these children are to provide a safe home while Ms. Pringle continues to work on her program.
Can I say something,
How
please?
long
Your Honor?
until? No, Brittany, thank you. How long until the segmented hair follicle test is returned?
I am not sure, Your Honor. It was sent out on Tuesday. I think they said anywhere from 1 to 2 weeks turnaround. I can follow with Mr. Jeffries to get a better idea.
And please see if you're so that you can provide me with that information tomorrow.
Yes, Your Honor.
Once that test is paid for, it can come back in 1 to 2 weeks.
I'm not sure why the concern of being paid for or not it is. As the test comes back, the test comes back, correct? CPS is going to take care of it because that's what they're going to do. I'm not sure what the relevance is of this test not being paid for.
Well, it would change the timeline.
I'm sorry.
That's my concern, is that how long is it if he's not going to release the results until he receives payment from the department? How long is it going to take for the department to provide the payment?
Ms. Ortiz-Tang?
Can I say something? Yeah, tomorrow
Please.
we have the custodian of records coming from Main Stop and coming with TDATs with the chain of custody. And in those urine screens, there's enough evidence for the concern to be validated. Based on Mr. Jeffries' testimony from a couple of days ago, if you have numbers that are over 25,000.
Well, let's not testify to.
No, I'm just repeating.
Not yet in the
I am
evidence.
repeating what he said. Then
Or
there's.
not-
So if we are allowed to please present our witnesses, tomorrow we'll have the chain of records, chain of custody that you requested, Judge. The custodian of records will be present to testify, and we'll get you admissible UAs that will cause enough to raise your eyebrows.
The final arguments expose the true battle underneath the entire case, whether the evidence demonstrates an immediate and continuing risk that justifies ongoing intervention. By this point, the court has heard competing explanations, disputed medical concerns, allegations involving substance issues, and extensive testimony about parenting decisions. Now the judge must determine which concerns are supported by evidence rather than fear. The discussion reveals a court wrestling with uncertainty. That's often the hardest situation for any judge. Clear cases are easy. Ambiguous cases require balancing caution against parental rights. One side argues that multiple warning signs combine into a pattern that cannot be ignored. The other argues that assumptions have been treated as facts. The outcome ultimately depends on whether the court believes the risk is current, substantial, and incapable of being managed through less restrictive measures. That final question carries more weight than every emotional accusation presented throughout the hearing.